be seated. This is the time set for oral argument in State against Fisher, our cause number 1CA CV130608. Counsel, as I'm sure you're aware and may have heard me say earlier today, we have read the briefs, we've conferred the case, and we are familiar with the issues. We are being videotaped in our oral argument today, and each side will have 20 minutes to present argument. From the appellant's standpoint, it's up to you to manage your own clock. When the 20 minutes turns to zero, your time is up. And with that, we can begin.
May it please the Court, thank you. John LeMaster on behalf of the appellant Fisher, Sand and Gravel. In this case, Fisher appeals from the imposition of a $500,000 civil penalty awarded by the Superior Court based on a petition for order to show cause filed by ADEQ. There are two issues on this appeal. The first issue is, did the court err in awarding $479,000 in civil penalties for Fisher allegedly operating without any permit whatsoever two hot mix asphalt plants, when in fact Fisher had two permits, one issued by ADEQ and the other issued by Maricopa County. The second issue on this appeal is whether the court erred in imposing $10,000 in civil penalties on Fisher for operating two crushers without a permit, when at the time they were operating the crushers, they had an application pending with DEQ pursuant to 18.2.503C, which allowed them to operate these crushers with the application pending. I'd like to talk about mainly the big issue in this case is a co-location issue, which is the penalty of $479,000. Again, the court found that Fisher had no permit whatsoever, and as a result, they issued $479,000 in civil penalties. In fact, Fisher had two permits, and this fact is undisputed. They had a permit issued by ADEQ, which was under an authorization to operate under the General Hot Mix Asphalt Plan.
Counsel, can you distinguish for me the difference between an authorization to operate and a permit? When do they come to play? What do they cover? And if they're the same, why don't they just call them one thing?
The difference is they are the same functionally. The difference is that certain permits are so widespread when you have a class of 10 or more of the same type. For a minor source, DEQ can issue what's called a general permit. And like here, they have the general permit for hot mix asphalt plants because there are a number of them operating throughout the state of Arizona. So rather than each individual who operates one of these plants having to go get an individual permit because there are so many of them, ADEQ publishes a general permit. And that general permit has all the conditions required by law to operate a hot mix asphalt plant. So what a permittee does, or a source does, is they file an application, and that's an application for an authorization to operate that hot mix asphalt plant under the general permit. Rather than in Maricopa County, for example, what happened here is they didn't have a general permit for this, so Fisher went out and got an individual permit to operate the plant in Maricopa County. The distinction is just how you get one, but functionally they are both permits.
When you say he got a permit, are we talking about the Glendale stationary plant, or are we talking about the, let's refer to it as the one that was originally the portable plant in Gila Bend?
There are two different permits. Mm-hmm. The permit for Maricopa County is the stationary one. It's actually a portable plant, but it was a stationary one issued by Maricopa County to have a hot mix asphalt plant at the what we call the El Mirage facility. In addition, ADEQ issued, and I'll call it issued, the general permit or the authorization to proceed under the general permit for a plant that had been operating in Gila Bend. They then did a move notice, followed all of the regulations for that move notice, and moved that Gila Bend plant next to the plant where the Maricopa County plant was operating at the El Mirage facility.
And so your contention, I guess, is that that co-location did not constitute the modification of a source.
It does not constitute the modification of a source.
But doesn't your own expert say that it was a co-located facility?
It is a co-located facility.
Okay, distinguish for us, would you?
There is no prohibition on co-locating facilities. You will look at the briefs. You will find not one statute. You will find not one regulation. And you will find not one permit condition at the time this existed that says a source can't co-locate facilities. There isn't a prohibition. Some of the
Well, if you have a source, I'm just trying to understand why it's not a modification of a source. If you have a source that's emitting X pollutants, and you co-locate, causing that site to emit 2X, that sounds in common parlance like a modification.
Well, one is you would have to operate, and we've never disputed this. If you co-locate them, all of the emissions, the combined emission limits, have to be in compliance with both permits. So by operating both plants, you can't exceed either permits. That's not alleged. In fact, the undisputed facts in this case are that Fisher operated both of these plants in compliance with the emission limits in both permits. The state says that's irrelevant. Hardly irrelevant. That is exactly what these are intended to do.
The state does say, do they not, that it's not your call as to whether or not the emissions ceiling is breached, that you need to file for a new permit that gives them the opportunity to come out and determine that that's the case. Is that not the state's position?
That may be the state's position, but there's no regulation at the time this happened that required that, no permit condition that required that, and no statute that required it. I'll be clear here. In 2012, the state adopted a new permit, and they adopted new regulations. And they did this, and these new regulations actually deal exactly with the situation Fisher finds itself in. This did not exist at the time Fisher did it, and we cited this, and this is R18-2-513. Completely new statutory provision. Importantly, this new regulatory provision, this new regulatory provision does not prohibit co-location. What it says is that if you're moving a portable plant under subsection D, you do exactly what Fisher did here. In addition, you provide two additional pieces of information that were not required when Fisher moved its plant. And those provisions are you give a complete list of equipment that will be located at the new location, and you provide revised admission calculations demonstrating that the equipment at the new location continues to qualify for the general permit under which the source has coverage. Those weren't in place. Now, so what Fisher did is they operated both plants so they would be in compliance with both permits, which is what they understood they had to do.
But, okay, there was also consent judgment.
There was.
And that consent judgment, if I recall, required the development and submission of some sort of plan.
Yes, it did.
Was that developed and submitted?
Yes, it was. That's not an allegation that did not happen here.
Was co-location included in it?
No.
I mean, it just seems surprising to me that if you're a regulated industry already under a consent judgment, it might be something you'd want to mention in your plan if you're going to locate facility.
I don't think the plan was that specific, Your Honor, but what they did is that it didn't say they could not do this. That's not what the purpose of the plan was. The plan was to improve the operations because Fisher had problems. That's why they entered into the consent judgment. All of the items in that consent judgment were released. These violations have nothing to do with what was alleged in the consent judgment. These are all, quote, new violations.
Right, but the consent judgment contemplated that there would be no new violations for 2 years. And this co-location
It's not a violation.
Well,
I mean, Your Honor, they could.
I understand how you can take that position. I do, but it seems that the supervisory element of the consent judgment could have been more carefully adhered to.
It could have been. The parties maybe could have done that. The state could have said a lot of things. But what we're here for is not that. What we're here for is, are these really violations of law? Is there any statute, regulation, or permit condition that was violated? And the simple answer is, when they moved this in 2011, the answer's no. And that's undisputed. There is nothing that said once you move these two plants together, those permits that are valid and exist disappear. They don't go away.
Let me ask you a question real quick, because you've brought us to that point to where once you move those two plants together, the stationary plant was permitted by Maricopa County.
Yes.
The co-located non-stationary plant, portable plant, was under an authorization to operate, and you've already addressed that, through the state. Once you bring those two together and co-locate it, what determines who the supreme authority is for those issues?
Well, again, because the stationary plant's only located in Maricopa County, there's no question Maricopa County has jurisdiction under the statutes.
But Counsel, I thought that what the state's arguing is that plant could be moved anywhere within the state.
No.
Was it limited by permit to Maricopa County?
Yes.
The batch plant.
The Maricopa County
the
plant.
Gila Bend. The Gila Bend.
No, I'm sorry. The Gila Bend plant can be moved anywhere in the state. The Maricopa County plant stays in Maricopa County. I'm sorry.
So if ADEQ is effectively permitting the portable plant and Maricopa County is permitting the stationary plant, they bring those two plants together. Who controls the issue of what rules apply?
Well, that right now, at the time they did it, both permits were valid. Okay, now they've changed that subsequently in 513. What they've done after Fisher did this is they did something. They said it's subsection E. And what they've said now in subsection E is if you move that state permitted plant into Maricopa County, you have to go to Maricopa County and it'd be covered under that permit, and the state permit then goes away. That wasn't in effect at the time. That was in effect in 2012 after this happened. So they've dealt a lot of what the problem here, they've actually had regulatory requirements in place to deal with this problem. They didn't have them in place. So at the time you had two permits, both of which were valid, both of which Fisher was operating under validly, both of which Fisher were operating so that the admission limits wouldn't exceed either permit, and then they get hit with $497,000 for having no permit whatsoever. That is not a violation of law. It's not a violation of the consent decree. They did everything they should have done. And that kind of brings us to the due process argument, which I'll briefly talk about. The due process argument essentially is regulated entities are allowed to have fair notice of what's required. In 2011, when they moved this plant, they followed every statute, every rule, and every regulation. They've amended those regulations, and in fact, they amended the 2012 permit to deal with the issue Fisher faces here. Now, they say those are a clarification, and those issues and laws were in effect at the time, but they weren't. The law is clear that if you change a regulation, that's a change in the law, that's a change in the standards. Importantly, Maricopa County twice looked at this plant when they were co-located. Maricopa County.
What I understand that the state objects to that evidence. I mean, is there evidence in the record?
There is evidence in the record. There's an affidavit. There's an affidavit from C.J. Garcia, who states that he was there. There are also the statements, letters from Maricopa County. They object because it's irrelevant. It is highly relevant. They object because it's hearsay. Well, the fact is it's not hearsay. These are governmental records showing
There was never an evidentiary hearing.
There was never an evidentiary hearing.
So we haven't had a chance to we can't simply accept this as undisputed fact, right? Because we're not procedurally teed up for that sort of analysis.
Well, you can accept C.J. Garcia's affidavit because it wasn't disputed. They haven't disputed the facts of what the county found. They just merely objected on hearsay, which it's not hearsay, it's a governmental record, and they've objected on relevance. That's the real objection they had, and that's the objection they state in their appeal, that this is irrelevant. How can it be irrelevant if Fisher is operating a county permit and they're operating these co-located plants, and the county goes out there and inspects it twice, and when they operate these two plants, the county would have said, hey, you're operating these two plants and it's violating the emissions limit in your permit. They didn't say that. They didn't say that because it didn't happen. And how is that irrelevant when that's exactly what these statutes and regulations are supposed to address? And you can find, as a matter of law, on Fisher's motion, regardless of the due process argument, that Fisher complied with every law, including statute, regulation, and permit condition. Briefly, I just want to talk about the 2012 permit, too, which isn't in effect. But there's all this statement about co-location being illegal. The 2012 general permit by ADEQ allows co-location. They again say, consistent with the new regulations, is you merely have to update your emissions. And the only time you need to go get a new authorization is when you have to change your hours of operation. So you could continue co-locating ADEQ permitted facilities under the 2012 permit without getting any new authorization, any new permit, as long as you didn't have to change your hours of operations. That is not an illegal act that allows co-location as a prohibited matter. And I see I have about 3.5 minutes left. I'd like to save the rest of my time for rebuttal unless the court has questions.
Thank you.
May it please the court, I'm James Scardon of the Office of the Arizona Attorney General, here for the state and ADEQ. Would like to begin by emphasizing a few main points. It's undisputed that Fisher Sand and Gravel took its state permitted portable plant and put it on the same property as the county stationary plant. It's undisputed that this increased and probably doubled the potential emissions from the site. Fisher is saying this did not violate any law.
Well, is there any contention that the total emissions violated the emissions allowed under either permit?
We do not contend that they actually violated it. The main problem is that they created a new stationary source which had no permit governing the potential emissions from that combined source.
Co-located two permitted sources, and you're not contending that they violated the emissions allowed by either permit, so...
Not in fact, but they operated a facility without a permit.
I mean, we're going to penalize them for violation in theory?
I apologize, I'm not sure. They did not. In actuality, they did not.
Well, let me direct you then to a legal question that I don't think we have briefing on. If you're not contending that the changes, whatever they were, be they co-location, creation of a new facility, or a new source, resulted in an emission greater than those allowed under the permit, what do we do with 49.426.01, which requires the promulgations of regulations, I'll just say generally more forgiving, but you could interpret it as to even abolish the permit requirement if the changes don't result in an emission that is greater than the emissions allowed under the permit?
49. Here's what we're contending the violation is.
Well, do you need a copy of 49.426.01?
I don't have it with me right now.
I think, but to follow up on Judge Swan's question is, has the director promulgated these rules? It says the director shall promulgate rules that address minor or changes in emission that do not exceed that allowed under the permit. I mean, our question is, have those regulations been adopted by the director?
Okay, 49.42601, that deals with Title V sources. Those are large sources that are coming under Title V of the Clean Air Act, major sources. They would not apply to this facility. This statute wouldn't apply to them.
Okay, thank you.
What was Judge Brown's question?
No, it was the same. Yeah.
Our main argument is that they were operating without a permit for the combined facility, and they're required specifically by the law
And who
to
do they
have a
apply
permit
to
for
for
that.
that permit?
Pardon me?
Once they co-locate, who do they apply to for that permit?
If they want, well, presently, or I mean at the time the violation was discovered, the state plant was under state jurisdiction. It's a portable plant that they got the permit from the state. If they had wanted to run that facility combined pursuant to a permit, they would have applied probably to the county for that. They could have, but they would have had to keep that state portable plant and change its status from being a portable plant to being one that operates only in Maricopa County.
So that, I'm sorry, go ahead. I thought you were done.
There's a process they could have used to do that. 182324 and I think the new 513 allow for that, but they have to specifically apply to the county for a new permit in order to change the status of the state portable plant, and they didn't do that.
So if there was an objection to be raised with the manner of operation, and by what I mean by that is the obtaining of these permits, getting all the plaques on the wall that show that you're permitted to do this thing there, if there's an objection to be raised by a party who was offended by their failure to obtain permission, it would be the county.
If they no, because until they obtain that permit, the state plant is under the jurisdiction of the state, and it's a violation of state law to operate that plant.
What's the definition of co-location?
Co-location is when you take two different or multiple equipment and sources and put it on one property and operate it.
Okay, what if that's a really big property? What if you've got 640 acres and you operate it at opposite corners? Is that co-location?
Well, it's considered one stationary source, and that's what we call co-location.
Even though they're a mile apart, or maybe 1.4?
If it's an adjacent, yes. It's really, you're coming right to one of our main points of the case. One point I want to make is that it's very clear under the law that you have to have a permit to operate any source. That's right there in statute.
I don't think anybody's arguing that.
All right.
I'm getting to what co-location is, and you can see the slippery slope I'm going to. So if you want to just address it,
Well, let me,
I won't lead
if I
you
could
through the
just
exercise.
state where we're coming from here. They created a new stationary source. They created a new source. Stationary source is defined as any building, structure, facility, or installation subject to regulation.
Okay, now let me ask my question again and see if you'll answer it.
All right?
How close do they have to be co-located? You said a mile is good enough, right? If they're operating within a mile of each other, that's co-location?
If it's a stationary source, co-located, which they created.
Can't use co-located in answering my question because I'm looking for a definition of co-located.
An actual definition, that's what we're calling co-location, is when
Okay,
you take,
so
when you
within-
take different sources and put them on the same property, you're co-located.
Okay, so if the same property happens to be 10 miles square, you're co-located.
Under the law, yes.
Which law?
Well,
That's what I'm looking for. I don't see the law that lends that sort of gravitas to what's a fairly vague response to my question.
No, when they took those two facilities and put them on the same property, we're calling it co-location, but what we're really saying is that they've created a new, larger stationary source that requires its own
So
permit.
if they have two plants, one fixed and one portable, and the portable moves within 10 miles, that's co-location. That's a new source.
On the same property?
What's the same property? The same parcel? Or
Yes.
owned by the same people? Okay, so what if
Yes.
they do a lot split? Now it's not the same source?
If it has to be the same type of equipment on the same or adjacent property under common control.
And they do a lot split and they grant an easement to the state to run a freeway through. Now is it co-located? Has that freeway suddenly changed the situation from a regulatory standpoint?
I don't know if that's adjacent or not. It could be.
Okay, and adjacent, does that come from the statute, or is that your language?
This is from the rule.
Okay, let's,
The rule is AACR 18-2-101-139. That's the current number. Stationary source, as I've said, it means any building, structure, facility, or installation subject to regulation, which emits or may emit any air pollutant. Building, structure, facility, or installation means all of the pollutant-emitting activities, all of them,
right.
which belong to the same industrial grouping, are located on one or more contiguous or adjacent property, and are under control of the same person or persons under common control. That describes what Fisher did here, and it's a lot closer than 10 miles.
It describes. I don't think they're disputing that that's a stationary source.
They're not disputing it, and then that ties into our main point is that the
Yeah,
statute
yeah.
says every
The-
source has to have a permit in order to operate. They say, well, we had 2 permits
Yeah, and where does it say that they can't do that?
because they created a new stationary source, and every
Is it
source has to
new?
have a
Was it
permit.
new or was it modified? And is
Well,
there-
if
and is
they'd
there a
modified
difference?
it, it would be the same problem, and it's the problem you raised earlier. What if they'd taken an engine and doubled the size of it without telling us? That would be a problem. That's effectively what they did by taking 2 plants
They
and
wouldn't
putting
have
on
to tell
one
you.
property.
They would have had to tell Maricopa County.
They could have if they'd wanted to. They didn't get a permit for any of it. They just decided that they think on their own they can take multiple.
Well, that's something we've been asking ourselves a lot about. I mean, they could have gone to either entity, ADEQ or Maricopa County, and either one would have been good enough. Is that your position?
Yes, and if they'd gotten the permit, we probably wouldn't be here.
Okay.
But as it is, what they decided to do, they doubled the potential emission from that part of property. They did it by creating a new source. Every source has to have a permit. By not getting the permit for the combined property, they denied the public the right to control what emissions come from that property through a permit.
Now, I understand what you're saying about the definition of a stationary source, but what regulation are you relying on? Is it 305 or 306? What is the best argument you can give me in black and white that says you can't have co-location? I know what the definition is, but where does it say thou shalt not co-locate properties without a permit?
A new permit.
A new permit. Where does it say
It comes from the definition of stationary source,
Okay, I understand that.
and then it comes from the rule saying
Coupled
every
with-
source has to have a permit to operate. 49-426, AACR 18-2302.
But I come back to the we're supposed to avoid absurd constructions. So if you have 2 pieces of property that are close to each other, but have a public road running between them, and you've got plant 1 on one piece of property, plant 2 on another piece of property, right? That's not co-location. They can use those plants according to their permits. We agree?
I don't know. Is that an easement for the road? Our
No,
point
no,
is that
the road is on deeded property. The state owns deeded property, and it's got a 20-foot wide road separating these 2 parcels. No problem. Am I right?
That would not, if that's not adjacent, then you're right, it's not a stationary source.
Okay. And then Fisher buys the road. Now we have 3 parcels. Still no problem, I think, because Fisher may own the road, but the parcels aren't adjacent to one another. And now for tax reasons, it consolidates the lot. Suddenly, it's running afoul of its permits? Because if that's your interpretation, I would want to see something in the statute that says that. The thou shalt not that Judge Brown referred to. It's one thing to have a definition. It's another thing to define the consequences of actions that don't make any material change in emissions.
Well,
Or violate
I've
permits.
said it, and they created a new larger source. Every source has to have a permit. That's clear in the law. They knew that. They knew it was a source. They knew they're increased their emissions. And here's why it's important. You have to be able, the public has to be able to calculate what emissions are coming from a property. And if
I thought
The
the public
polluter-
had to be able to calculate what emissions are coming from a permitted source.
right,
And you have emissions allowed for source 1, you have emissions allowed for source 2. They move closer together, but those emissions don't exceed the total permitted
But
emissions.
it's not up to the operator to decide whether whether the emission regulations are complied with. The state has to know of it.
I guess my problem with this argument is that the state doesn't contend that the operator was wrong. The state doesn't contend that the permitted emissions have been exceeded.
But they did not get a permit so that we were able to evaluate the facility. It's not getting the permit that's the violation for the combined facility. It's increasing the potential to emit. You've taken it totally out of the control of the public and allowed, as I said before the Superior Court, under their logic, they could put 5, 6, 7 pieces of equipment on that property and run them all under their own permits. They could do that under their logic, and we wouldn't be able to do anything about it. But the way the stationary source is defined, that forces them to say that's a stationary source, and every source has to have a permit. That's why that law reads the way it does, that every source has to have a permit, and that's one reason stationary source is defined as it is.
Is it a condition in either the state or the county permit that co-location won't be allowed without a new permit? Do you put people on notice of this?
Effectively, yeah, if you look at what co-location is allowed under the new permit that they've cited.
No, under the permits they had, were they on notice? Did the state permit say, yeah, you can use this anywhere in the state, but don't co-locate?
Well, the permit only allows what the permit says it allows. It's not intended, we can't think of everything that they can do.
Okay, but the permit allows them to emit so much.
Exactly.
And they weren't emitting more than that, or at least you don't contend they were. So isn't that really the fundamental purpose of the permit?
No, because they could have emitted more under their argument that we didn't have any control over how much they emitted. They said voluntarily on their own they stayed within the boundaries of the county permit, but there was no control over their ability to do so. There have to be conditions put on the combined property to make sure that they don't do it.
I'm sorry, but I am far from an expert in asphalt manufacture. Tell me how it is that by moving the plant closer to another plant, they put themselves in a position to emit more than the permit allows.
Each
there some
permit
synergy?
allows whatever its own permit allows.
Right.
In terms of
but
emissions.
is
If you
there
put them together, you've doubled the potential emissions from that property.
Well, you've doubled the potential emissions from that property, but not doubled the potential permitted emissions. I guess what I'm saying is, factually, is there something about putting these two plants together that makes 1 + 1 more than 2?
No, but the problem is the two may not be appropriate for that site. And within that jurisdiction, there could be other controls for a larger source.
Okay.
And the public was never given the right
That answers my question. I appreciate
to
it.
do that. They're essentially arguing that it should be up to them to decide what pollution comes. But there has to be a permit controlling the entire site. And that's why every source has to be operated according to a permit, and why stationary sources are defined as including all facilities of the same type. They raised the crushers. They didn't file a complete application. They never disputed that they didn't file it. You can't get the permit coverage unless you actually file an application. There's no facts on that. They talk about jurisdiction. I would say ADQ retains jurisdiction over that portable plant.
Based on?
Because under 49402A6, the state has original jurisdiction over portable plants.
Okay.
We issued them their permit. They came to us for the permit. That permit had not been replaced as required by law. If they did not want state jurisdiction over it.
And I know you may be getting tired of hearing co-location questions, but if Maricopa County has the stationary plant and ADEQ has responsibility for the portable plant, you put them together, and I believe everyone agrees that results in one stationary plant.
Yes. Well, not stationary. I mean, if they it depends on how they get the permit for it. They may want that to be a county portable plant, is what I'm saying. That's a minor detail.
So then the position is not that if you take those two things and put them either on the same property or adjacent, that it is a single stationary plant?
I see what, I'm sorry, I missed that. If you put, it would be a stationary source, yes.
Okay. It's a stationary source. It is a single source at that point.
Yes.
And ADEQ can continue to be entitled to regulate an aspect of it, and Maricopa County has another aspect of it?
Unless they got a county permit. Is that what you were asking?
I'm just asking
Oh.
because
Yes. The state plant stays under state jurisdiction until they take it out from under state jurisdiction.
and if they had done what you want them to do or what you believe was appropriate for them to do, they would have gone to Maricopa County and they would have requested for the conjoined units that are now one stationary plant, a single permit addressing output from those facilities.
They could have done that, yes. They did not.
And if they didn't do that, then who had the right to object? Was it Maricopa County, who they would be getting the permit from? Or was it ADEQ, who seemingly, once it was a stationary plant, didn't have
It's
an interest in it anymore, effectively?
the only way that it would not be of interest to the state, and the only way we would not assert that we had jurisdiction over it, was if they got a county permit taking that plant out from under our jurisdiction. They did not do that.
So
It remains
ultimate-
a state portable plant that is being illegally operated as part of a larger stationary source that doesn't have a permit.
And let me ask it this way, so that hopefully we can use kind of a maybe an improper term, but I think it'll get the point across. If they don't get the county permit, then the monitoring of that site defaults to ADEQ under its overriding
Permit,
jurisdiction.
then each entity has jurisdiction over its plant.
Okay.
That's why we're here. If we didn't have jurisdiction over that, we wouldn't be here.
All right. Thank you.
Thank you.
Thank you very much.
May it please the court, I just want to address a couple of items. One is there is no definition of co-location. No statute, no regulation. Cites that the 2012 permit does talk about it, but there's no definition. The definition is of a stationary source. And there's no definition of a single stationary source, and there is no single stationary source rule. All the definition is a stationary source.
But doesn't it kind of make sense that under the definition, whether it makes logical sense or not, it makes linguistic sense that under the definition, when you put these on the same or adjacent parcels, they become a stationary source?
And they do become a stationary source, but we've never disputed that. The issue is do you need one permit? And the answer is no. There's no regulation, statute, or anything that requires one permit. Their view is that these two valid permits, that nobody disputes, two valid permits, evaporated. And they didn't evaporate. They didn't go away. There's a procedure that if DEQ thought that, they're violating this permit or doing something, they had a procedure in place, and it's under R18-2510. And that says that the DEQ, when somebody's doing an authorization to operate and they violate the general permit conditions, they can make the source get an individual permit. That's what it says in I believe it's subsection B. They're notified, you're required to go get an individual permit if you're violating the general permit conditions. They then have to give a written notice, and that written notice is very specific on some of the things it says. The written notice says it has to be sent certified mail, so they actually get the written notice. 2 is you have to tell them what the violation is. And 3, you have to give them an opportunity to go out and get this individual permit. And your general permit is still valid till the earlier of either 180 days or you get the new permit.
Of course, you have a consent judgment here that alters the due process
No.
somewhat, doesn't it?
No. They still have to prove a violation. All the consent judgments did.
Proving a violation and these prophylactic procedures, though, are two different things. We're running out of time, but let me come back full circle then. Going back to the regulation we talked about first. If you agree that the co-location, used loosely, makes this a stationary source, and something changed to make it a stationary source, didn't your client commence construction of, operate, or modify a source by doubling the capacity of the source?
No.
It's not a modification?
No.
Bringing the plant onto this newly enlarged stationary site did not in any way involve construction?
It did not modify a source, because remember,
just put it in park and start it up?
remember this portable plant can be operated anywhere, including in Maricopa County, anywhere in Maricopa County. And there is no requirement, because it's not modifying that permit. I can operate it in Gila Bend, I can operate it in Maricopa County. The importance of that section and that definition is to do exactly what the new regulations requires you, is you don't emit emissions in violation of your permit. That's the intent. It doesn't say you can't locate, doesn't say you need to get a new permit. Nothing says that.
Well, it says you can't modify it without getting a permit. You may have a permitted facility, and yet if you want to modify it, you have to get a permit. It does say that.
Not on the application to proceed under a general authorization of a general permit. That permit is valid anywhere in the state of Arizona. And the definition of stationary source doesn't say you need to get a new permit.
No, but Section 302A says you need to get a new permit.
If you modify that permit, and they did not.
No, if you modify that source.
That source. But they didn't modify the source because they operated within the limit, and there is, again, no allegation. There was nothing in any regulation that required a new permit. There's nothing in the regulations that said this permit became invalid. In fact, what they did is they did notify the state, and they did notify Maricopa County, as they're required to do when they, quote, co-located these. And they gave all the information required. The point is that there is no statute, regulation, or permit condition that was violated. And in order to have a violation, that's what they need to prove. Unless the court has further questions, I'm out of time. Thank you.
Thank you. Matter is now under advisement. We'll issue a written decision in due course. We stand adjourned.